different types of intellectual property rights. Design can be protected with different forms of intellectual property rights. And studies show that the strongest protection is created with a combination of different forms of IP rights. Intellectual property rights are typically divided into two categories: copyright and related rights on one hand, and industrial rights on the other. Industrial rights include, for example, design rights, trademarks, patents, and utility models. Let's go over these different forms of intellectual property rights and how do they protect design. In EU legislation, design rights protect the appearance of a product, including its shape, patterns, colors, and ornamentation. This can cover anything from the design of a car to the car handle to a piece of furniture or clothing, or a design of an icon in an app, for example. The new design legislation will extend the protection further to non-physical products. Design rights protect the visual aspects, allowing designers and businesses to secure exclusive rights over the aesthetic elements of their products. To qualify for protection, a design must be new, which is the novelty requirement, meaning that no identical design has been made public before the application date or before it was first disclosed. And two, have an individual character, meaning it gives a different overall impression from existing designs. This is important to understand. The design does not need to be absolutely market disruptively new. Sometimes designers especially place the threshold of design protection higher than it actually is. Also in EU, there is a grace period of 12 months, which means that a design can still be registered within 12 months of it first being published. However, it is absolutely recommended to register before publishing your design. To obtain EU design, the designer or small and medium-sized enterprise must file a design application within EUIPO. The applicant submits a representation of the design, so drawings or photographs, along with a description and a list of products which the design will be applied if necessary. The strength of the design relies heavily on the decisions made during the filing process, and this is why it is important to utilize the expertise of a good design attorney to get the strongest possible protection. Once registered, the design is first published, and then the design right gives the owner exclusive rights to use the design and to prevent others from using it without permission. The design owner can enforce their rights through legal actions against unauthorized use. This protection lasts up to 25 years with renewals every 5 years. Unregistered designs offer more limited protection. While they protect against direct copying, they do not protect against independent creation of a similar design by another party. Utilizing unregistered design can be a good tool to protect designs in industries where products have short market lifespans, or when one has missed the registration period for an EU design. But defending unregistered designs can be costly, especially taking into consideration the relatively short protection period it allows. Trademarks. Trademarks help customers identify where a product or service comes from. In EU legislation, a trademark is a sign or symbol that distinguishes the goods or services of one company from those of another. This can include words, logos, slogans, shapes, or sounds, or colors. The purpose of a trademark is to protect the brand identity of a business by ensuring that the consumers can clearly identify the source of a product or service and preventing confusion in the marketplace. When it comes to design, a trademark can protect the design brand, the name of a product, the designer themselves, and the company selling the design product, for example. In case someone markets their products under a design brand, and that doesn't belong to them, trademark legislation gives you tools to prohibit that kind of use. To obtain protection, a trademark must be registered within the EUIPO. The applicant should provide a clear representation of the trademark and lists of goods or services it will cover, classified under the NIS classification system. This means that the same name or logo, for example, can be used for different products or services as long as those trademarks are registered in different classification categories. Once published, third parties have the opportunity to oppose the registration if they believe the trademark conflicts with their existing rights. If no opposition are filed, or if they are resolved in the favor of the applicant, the trademark is registered and published in the EU Trademark Register. Once registered, the trademark owner has exclusive right across all EU member states. Only the trademark owner can use the registered mark in relation to the goods and services it covers, and the owner can take legal actions against anyone who uses similar or identical signs that could confuse consumers and customers. EU trademark is initially valid for 10 years from the date of filing. The registration can be renewed indefinitely in 10-year periods, provided that the renewal fees are paid and the trademark is genuinely used. Patents and utility models. Patents are a form of industrial rights that provide inventor an exclusive right to their invention, allowing them to prevent others from making, using, selling, or distributing the patented invention without the permission of the right owner. In Europe, a patent can be granted for an invention that meets 3 criteria: novelty, inventive step, and industrial applicability. Utility models, sometimes known as mini patents, are a type of intellectual property protection for innovations that are generally simpler or have a lower threshold of inventiveness than those required for a patent. Not all EU countries recognize utility models as a form of IP protection. One important thing to note with patents and utility models is that the novelty requirement is absolute. This means that in case you publish your invention, it is no longer considered new, and the patent or utility model criteria is no longer met. So there is no grace period for patents and utility models. Utility models generally offer protection from 6 to 10 years, whereas patents can be valid for up to 20 years. Again, patents and utility models give the owner an exclusive right to prevent others from commercially exploiting the invention in the countries where the patent or utility model is valid. Copyright and related rights. So let's now view the other part of intellectual property rights, where industrial rights make up one part and copyright and related rights make up the other part. Copyrights protect original works that express intellectual creativity. Typical examples of copyrightable work being books, movies, graphics, music, paintings, and designs. According to EU legislation, copyright refers to a range of rights granted to authors, performers, producers, and broadcasters, and also designers. And those rights are further divided into economic rights and moral rights. In order for any work to get copyright protection, the work must be original. That means that the work bears the imprint of the author's personality, their sensibility, their non-imposed choices, and their perception of the subject. So copyright protects only the specific expression of the work. The same idea, the same concept can be used by others freely, and others can get their own copyright protection as long as their work is also considered original. One of the great benefits of copyright protection is that in many countries and in EU, copyright is granted automatically, as long as the work is considered original. So no registration is required. Copyright protection period is also long. Copyright can be valid from the time that the work is created until 70 years has passed from the author's death. While gaining copyright can be smooth, proving that you have copyright protection can be time-consuming and expensive. When it comes to protecting design, it's good to keep in mind that copyright very much applies to design the same way as it does to other creative works. However, combining copyright with industrial rights, such as design rights and trademarks, for example, leads to a stronger protection than copyright alone. Copyright gives the right owner an exclusive right to utilize copyrighted work and to prevent others from utilizing their work without permission.